Hi everyone, Daniel Trustmore here. We're going to continue on with our third part of our video on evidence for the bar exam, covering hearsay. So what do we mean by hearsay? Well, first off, before we delve into the topic of hearsay as a statement made outside the court by a declarant, we want to first ask preliminary determinations. So the judge makes preliminary determinations about hearsay. These are questions about law and fact. And the judge will ask a question such as, is this a statement? Is it offered for the truth of the matter asserted? Do exceptions to hearsay apply? The standard of evidence which the judge will apply is the preponderance of the evidence standard. Party offering evidence bears the burden there. So 801C is where we get the main hearsay rules. Hearsay is an evidence containing, as stated before, the statement made outside of the court by a declarant. When we say statement, we mean an assertion plus a declarant, where an assertion is assertive as an oral or written piece of conduct or some sort of intentional communication. Whether a reasonable person under the circumstance would have intended the assertion is a question. Declarant is a person, a human being, who makes the statement. Statement must be generated by a person with his or her own knowledge. Animal-generated communication is not a statement. Machine-generated communication, if it's fully automatic, it's not a statement. But if it's informational or signals which originate from a human, that can be viewed as a statement. Statements in the context of hearsay may be oral, they may be written, they may be signals, or they can even be silence. And yes, word, signal, silence, email, audio tape, web page with words, these are all examples of statements. However, if it's simply a photo or video documenting scenes without commentary, editing, or web page without words, that's more likely not to be viewed as a statement. And so usually the statement that is an out-of-court statement is offered for the truth of the matter asserted. I like remembering this as toma, like to take, or he takes in Spanish, or she takes in Spanish, toma. Truth of the matter asserted in the statement, the only purpose. So if offered to make the fact finders believe that the statement is true, that is what we're looking for in the context of hearsay. What is it being offered for? And so another purpose is not being offered for the truth of the matter. It can come in as circumstantial evidence to show the speaker's personal knowledge, intent, state of mind, premeditation, bias, difference between you and thought, state of mind. To impeach a witness, show that witness said different things at different time. To give notice to, show effect on the listener. Publication in a defamation case, legally binding statement, I accept your offer, offered for multiple purposes. So hearsay exceptions, and there are a number of hearsay exceptions. To heighten reliability and need or usefulness, hearsay is inadmissible unless a federal statute like the FRE or rules by the Supreme Court apply. Note, we exclude hearsay for policy reason, not based on evidence, on relevance. Hearsay within hearsay, a statement that contains multiple levels of hearsay is admissible if each level of hearsay falls within an exception. So you might say, she said that he said that she said, as an example of hearsay within hearsay, and each one needs to have an exception. Exclusions from hearsay, statements that are not hearsay, therefore admissible. A declared witness's prior statement, witness in the courtroom exceptions. This is 801D1 as an exception. So note, prior inconsistent statements offered to impeach the witness are not hearsay because they're not offered for the truth of the matter asserted. Show that they're offered instead to show that a witness might have said different things. The declarant testifies at trial as a witness, is subject to cross-examination about his or her prior statement. Prior sworn inconsistent statement that was inconsistent with courtroom testimony at proceedings like the grand jury hearing, trial, deposition, not statements to police, given under oath, penalty, or perjury. Note that prior sworn inconsistent statements offered to impeach a witness are not hearsay because they're not offered for the truth of the matter asserted. They show that the witness said different things. So the prior consistent statement is another example that was consistent with the testimony that declarant witness's credibility has been attacked, like an improper motive or influence. The statement is probative in rehabilitating credibility. Consistent statement can rehabilitate only if it occurred before the motive arose. So prior identification to identify a person doesn't have to be under oath, don't need some inconsistency. 801D2, an opposing party statement, admission by party opponent, party admission exception. Note the most used hearsay exception but differs from all of the others because it is not based on reliability and or need based on the idea of estoppel. Party can't deny their own statements. So a statement offered against a party is not hearsay, therefore inadmissible if it is the party's own statement, or the parties adopted or believe the statement or silence to be true, or the party or the person making the statement was authorized by the party to speak, or the statement was made by an agent, employee acting within the scope of the relationship, or a co-conspirator during and in furtherance of conspiracy. All three there. So look for this as a party admission exception under 801 D2, an imposing party statement. It is the most used hearsay exception, but again, it differs from all of the others because it is not based on reliability and or need, based on the idea of estoppel, where a party can't deny their own statements. And if that statement is offered against a party, it's not hearsay, admissible if it's the party's own statement, party adopted it or believed it to be true, person making the statement was authorized by the party to speak, or the statement was made by an agent, employee acting within the scope of the relationship, or a co-conspirator during and in furtherance of conspiracy. There are two limits, however, for the opposing party statement. The declarant must be a party. Some key declarants aren't parties. Victim in criminal prosecution, statement must be offered against the party declarant, no self-serving statements. In some cases involving multiple defendants, these provisions allow the plaintiff to introduce one statement against all of the defendants. Similarly, a defendant sometimes can introduce one plaintiff's out-of-court statement against all of the plaintiffs. The trick is to find adoption, authorization, agency relationship linking the multiple parties. This exception is very broad, applies to any statement by a party, any time, place, any person, whether it was made under oath or anticipation of litigation, doesn't matter. Can be anything opponent wants to offer. Statement does not have to be an admission. Perfectly innocent statements are admissible. Party's availability is immaterial, can offer statements even if party testifies is deceased. Professor's examples are these opposing party statements. The prosecutor offers the defendant's confession, yes. A civil defendant offers deposition testimony of the plaintiff. That is an opposing party statement. A civil plaintiff offers a diary entry written by the defendant, yes. Prosecutor calls defendant's girlfriend to testify about what defendant told her about the crime. That is an opposing party statement. Civil party plaintiff offers email sent by the CEO of the defendant corporation. That is also an opposing party statement. Civil defendant plays video of the plaintiff making statements to a news reporter after the incident. Yes. Prosecutor offers letters written by defendant of his family members while he was in jail. That's a yes. Open question whether one defendant can offer out-of-court statement against another. The Breton problem. In a joint criminal trial, incriminating out-of-court statement made by one declarant cannot be offered to incriminate another defendant, and his or her opportunity to confront or cross-examine under the Sixth Amendment. Because remember, you do have the Sixth Amendment right to confront those who testify against you. Confrontation clause. Redacting the statement may fix the problem, so it only incriminates the original defendant. Limiting instruction won't, however. A jury will misunderstand or disregard the instruction. Statement that does not refer explicitly to a co-defendant and that contains no obvious omissions tempting the jury to fill in the gaps satisfies the Breton rule. In a civil case, a judge might be willing to admit the statement with a limiting instruction, instruct the jury to admit or exclude it under 403. So we've got more of these hearsay exceptions here. So always look for a hearsay exception. Exceptions to the rule against hearsay, but these are actually where you do have hearsay. The other examples that we talked about were not hearsay because remember, we're looking for an out-of-court statement offered for the truth of the matter asserted. However, you might have other examples of hearsay, but that are actually admissible. So these might include, for example, regardless of whether the declarant is available as a witness, present sense impression, a statement describing an event and made while or immediately after the declarant perceived it does not require subjective excitement, allowed even for boring events, no analysis, only description with no other information added. So describing the event while it occurs, since policy reasons, it's more likely to be true if it's if the statement is being made while the event is actually happening, or it's made while or immediately after the declarant perceived it. That's present sense impression. A lot of different examples, like me, a talk show host talking about some sort of game, like a game show host, or a sports announcer, for example. I like to think about it like a sports announcer, someone describing a game, talking about it while they're perceiving it. You don't really need the subjective excitement. It's allowed even for boring events. So if you've got I don't know, something boring. I don't mean to diss any sport, but if you've got a boring sport, I won't say the sport. But if you've got a boring sport, that's even allowed. You don't need analysis, only description with no other information added. So excited utterance is another one, a statement relating to a startling event or condition and made while the declarant was under the stress of excitement that it caused. So it might be a witness to a murder and then someone calls 911. That might be an excited utterance example. Statement relating to a startling event condition and statement made while the declarant was under the stress of excitement that it caused. May occur longer after an event as long as the speaker is still excited. Requires that subjective excitement piece, can include analysis of an event. And so state of mind, then existing mental, emotional, or physical condition. A statement of the declarant's then existing at that time the statement was made, state of mind, emotion, sensation, physical condition. It's different than an excited utterance, then existing mental, emotional, physical condition. So it's any expression of what the declarant felt or thought at a particular moment. Like, oh, I'm so distressed. It could be intent, plan, motive, design, mental feeling, pain, bodily health, admissible to show that he believed or remembered something at that time, but it's inadmissible to prove the truth of the fact that he believed the memory or remembered the belief. It's just to prove that state of mind. So must refer to the internal state, not to external events that cause the state of mind. So we watch for statements such as I believe or I remember, that's external. Like I believe or I remember. You want to look for something like I felt, I thought. Admissible if offered to show that he remembered or believed something at the time, but inadmissible to prove the truth of the thing they believed or the truth of the thing they remembered. So under the Hillman doctrine, the plans with others seems to overrule Hillman by limiting the state of mind exception to the declarant's own plan. However, judges will admit declarant's plans with others when the facts are sufficiently compelling. If we look for forward-looking statements with the Hillman twist, like where male tells a female, I'm going to meet Jay for lunch at Vegetarian Palace next Monday, that's admissible under the state of mind exception to show M's intent, state of mind plan. Admissible as circumstantial evidence of M's whereabouts on the next day. Admissible under Hillman if offered to prove where Jay was next Monday. So other state of mind exceptions, and there are other examples where these overlap. I got these from our professor. Thank you so much. I'm flying to San Diego tomorrow as a state of mind. I hope Grandpa dies and leaves me the family estate as a state of mind. My head hurts so badly I can barely stand it. State of mind and excited utterance. Yesterday my head hurt so badly I could barely stand it. No, it's not. It's not a state of mind because it's a then existing. I hate Melissa. I wish she had never been born is a state of mind. I love you is a state of mind. I loved you from the moment I saw you. It could be a state of mind. I'm going to pick up some pizza on the way home from work is a state of mind. I'm going to rob the First National Bank on Thursday is a state of mind. Jerry and I are going to rob the First National Bank on Thursday. The Hillman doctrine issue, where it's a plan with others. Judges will admit declarants plan with others when the facts are sufficiently compelling. So you have to look for that compelling. Another example, I saw Jim hit Debbie in the face. That's not an exception. I believe Jim hit Debbie in the face. That could be to show the declarant's belief could be admitted, or to prove that. But if it's used to prove that Jim hit Debbie in the face, then no. I'm going to rent the car from Hertz is a state of mind. And other examples of excited utterance, just look for a statement relating to a startling event or condition and made while the declarant was under the stress of the excitement that it caused. May occur longer as long as the speaker is still excited, requires subjective excitement, can include analysis of an event. And so more examples for exceptions to hearsay. We've got a lot more of them to cover here. The exceptions are where a lot of multiple choice questions are tested. So another example is a medical treatment or diagnosis. A statement made for purpose of medical diagnosis or treatment describing the following as long as they are reasonably related to the diagnosis or treatment, medical history, past or present symptoms, pain or sensations, or the general character of the cause of the above to know the type of force applied to injury. Can refer to past events. But this is different from state of mind, present sense impression. Past doesn't count, however, here. In state of mind and past or present sense impression, the past can actually count here under medical treatment and diagnosis. Different from excited utterance, too far in the past doesn't count. So it does not have to be made to a doctor, can be made to any person, does not have to be made from a patient, can be made from any person, does not include ones from doctor to patient, but include patient to doctor. Where the patient's special interest in telling the truth to get appropriate medical care. This exception comes up in prosecutions for domestic or child abuse. Patient's statement to the doctor to prove the abuse occurred is admissible. So remember, to prove identity of the abuser is kind of tricky. Some might argue that treatment involves the identity of the abuser because doctor needs to know this so he can keep the patient away. And that is the medical treatment diagnosis. Another exception to hearsay is a recorded recollection, where the declarant must appear as a witness in the courtroom exception here. So here a record or we're looking for a record or memorandum that the witness once had personal knowledge but has forgotten. Knew once but cannot remember enough to fully testify accurately. Witness made or adopted the record when the knowledge was fresh in his memory, and witness testifies that it accurately reflects his knowledge. So recorded recollection complements the process for refreshing a witness's recollection. Anything can be used to refresh the witness's recollection, but the witness gives in-court testimony from his refreshed personal memory. Once anything is used to refresh recollection, it cannot be introduced as evidence because it itself is hearsay. To prevent hearsay from having more weight than other testimony, the witness reads it into the record. However, an adverse party may introduce the same evidence without hearsay problem as long as it is not introduced for the truth of the matter asserted, witness's credibility. Business records, witness lays foundation that the record was kept in the course of a regularly conducted business activity. Making record was part of the business's regular activity. Made at or near the time by someone with knowledge, qualified witness, or certification. Business, almost any organized activity, profit or non-profit. Record of an act, event, condition, opinion, diagnosis. The nature of opinion in the record doesn't matter. Statement by someone within the organization is a business record, not hearsay within hearsay. But a statement made by third-party eyewitness is not a business record. Watch out for this hearsay within hearsay. Challenger of the business record exception may rebut it by showing that circumstances indicate lack of trustworthiness. Documents prepared in anticipation of litigation usually excluded on this ground. Look also for a public records exception, which is another popular exception that the bar might test on. And in this exception, public record, all levels or branches of government. Private organizations don't really count for this. Society for the Protection of Cruelty to Animals, for example, they must satisfy the public records requirements. They're more restrictive and not just business records. For example, political party, Democratic Party is not a government office but counts as a business record but not a public record. In criminal cases, if both business records and public records exceptions apply, then they must meet the public records exception protections for criminal defendant. So admissible for government office activities, matters observed while under legal duty to report, like weather reports, any ministerial natural observation by public office, for example, police, law enforcement, etc. That's admissible. What's not admissible is any records that lack trustworthiness, statements by a third party without a separate hearsay exception, and just keep watching out for hearsay within hearsay. And remember, this is not admissible against a criminal defendant. Matters observed by law enforcement personnel, like a police report, not admissible against a criminal defendant unless the observation was ministerial. More like a neutral observation, that might be admissible. And also look for example, a record of license plates crossing the border. Factual findings in an investigation include opinions and conclusion by any public offices. So ancient documents, statements in a document that is at least 20 years old and proponent establishes authenticity. It's now limited to those prepared before January of 1998. Even when a document qualifies as ancient, it often contains hearsay within hearsay. Watch out for statements by third parties nested within ancient documents. So another one is, so yes, that's 20 years old. Look for hearsay within hearsay. Market reports and similar publications, market quotations, lists, directories, or other complications that are generally relied on by the public or by persons in particular occupations. Includes only lists and other data compilations. More discursive writings do not fit within this exception, even if public generally relies upon the source. Another example, other than market reports and similar publications, which are generally relied on by the public, like for stock data, for example. Learned treatises. These are a statement contained in a treatise if the statement is called to the attention of an expert witness on cross-examination or relied on by the expert on direct examination. Publication is established as a reliable authority by the expert's admission or testimony, by another expert's testimony, or by judicial notice. If it's admitted in this case, a statement may be read into evidence but not perceived as an exhibit. During examination of expert, a publication established as a reliable authority in same field may be read into evidence by the expert but not given to the jury. Not admitted as evidence, relevant portions are read into the record. A party may use one of these treatises only in connection with expert testimony. So 3 categories on 803 exceptions: hearsay but admissible regardless of the declarant's availability as a witness, need and reliability of declarant witness's statement. These are witness in the courtroom exceptions, such as prior and consistent statement, prior identification, recorded recollection, immediacy of the declaration's excitement, unlikely to have time to formulate a lie. These include present sense impression, excited utterance, state of mind, and self-interest of the declarant has strong reasons to be truthful. Statement for medical diagnosis or treatment, business record, public record. So other exceptions to the rule against hearsay. Remember, just hearsay, but the declarant must be unavailable for the evidence to be admissible. We've got criteria for being unavailable, 5 types of unavailability. There's privilege, refusal to testify, lack of memory, which is real or feigned, death, illness, or absence. These are all different examples where the person claiming memory loss is subject to cross-examination, but must start by showing that the declarant is unavailable. These are the unavailable witness hearsay exceptions. Before we accept that unavailability, we need to ask several questions. 1, a party can't use wrongdoing to procure unavailability. We have to get a good statement, then bump off the witness. A party may have to take steps to get witness to court, like make efforts to procure, especially in a civil case. If possible, party may have to take unavailable witnesses' deposition. But for several of these types of unavailability, you just don't have that option. The first one we'll talk about is under 804b1 for former testimony. The declarant is unavailable. Prior statement was given at a trial, hearing, or deposition. Opponent predecessor had opportunity to develop testimony. Predecessor works only in civil cases, and opponent had similar motive interest to cross-examine. So it doesn't matter if opponent actually cross-examined. Now there's a difference between 804b1 and 804d1a. 804b1 is in this exception for former testimony, the declarant is unavailable. Prior testimony was made in a proceeding where there was an oath with opportunity and motive to develop. And in 801d1a, that's where a declarant is on the stand subject to cross-examination. Prior inconsistent statement made under penalty of perjury in a proceeding. A second example under these lists of exceptions for unavailable witness, dying declaration. This is the most colorful of the hearsay exception. It's very popular on the bar exam, very dramatic. So declarant is unavailable, usually dead, but this is not required. Applies only to homicide prosecutions and civil proceedings, not to most criminal prosecutions. Declarant subjectively believed death was imminent, soon and inevitable, in shadow of death. Statement concerns cause or circumstance of death, not other matters. Note, when you have a dying declarant, consider other forms like excited utterance, state of mind, present sense impression, statement to obtain, maybe some other exception. So another example is statement against interest. The declarant is unavailable, and the statement that was against their own interests. So pecuniary or proprietary interests, civil criminal liability, render invalid a claim. Moral physical interest does not count. Even if it falls within one of the approved categories, it must be one that no reasonable person would have made unless it was true at the time it was made. Corroboration for statement against penal interests offered in criminal cases. As with other preliminary determinations, the judge decides corroboration by considering a wide range of factors, but reluctant to admit these statements. Declarant's trustworthiness and of statement's truth. So look for a statement against interests, where they might render invalid a claim or cause civil or criminal liability. Like they must be true, because why would someone make a statement against their own interests? Forfeiture is another example. Statement offered against a party that wrongfully caused the declarant's unavailability. Declarant is unavailable. Other party engaged in some wrongdoing or acquiesced in wrongdoing. Courts construe acquiescence broadly, especially in context of a conspiracy. If one member of a conspiracy coerces or kills a potential witness, that witness's statements are admissible against all members. It's intended to cause unavailability there. Opposing party must specifically intend to make the declarant unavailable. Wrongdoing that caused that unavailability. So I like to think about this as like threatening someone to speak or to testify. That might be where forfeiture actually falls in. Another example is a residual exception. It's rare. We don't really overuse it. Identifies ad hoc situations in which reliability and or need are high. In the hearsay statement, not one of the 803, 804 kinds is not excluded if the plaintiff must provide notice before relying upon 807, but this is easily accomplished. Has equivalent circumstantial guarantees of trustworthiness. This near miss qualifies, or the near miss qualities of other exceptions of a statement support trustworthiness. Is offered as evidence of a material fact, is more probative than any other evidence and that the proponent can reasonably procure or obtain, and admitting it will serve the interests of justice. So there's a difference between hearsay policies and the residual exception. Hearsay is an out-of-court statement where it's more reliable and necessary than most. Residual is an out-of-court statement, has guarantees of trustworthiness, and satisfies an important need. So look for the need in any sort of public policy arguments to justify the residual exception under 807. So Posner says he would use a simplified version of 807 and allow hearsay when it is reliable. The jury can understand its strength and limitations, and it will materially enhance the likelihood of a correct outcome. So attacking and supporting the declarant's credibility, treating declarants as witnesses. When the hearsay is admitted, opponent can attack, support the declarant's credibility as if declarant had testified. Attack 4, required witness capacities, perception, memory, narrative capacity, sincerity. The court may admit evidence of the declarant's inconsistent statement or conduct, regardless of when it occurred, or whether the declarant had an opportunity to explain or deny it. Party cannot use extrinsic evidence to show inconsistent statement on a collateral matter to prove dishonest acts that witness denies under 608B. Party can use extrinsic evidence to show impairment of mental facilities. Previous felony conviction, if it satisfies 609, doesn't have to be a crime of dishonesty. Think about the 10-year rule of 609. So the party against whom the statement was admitted may call the declarant as a witness for cross-examination, and look for, that's actually an important rule. 806, attacking and supporting the declarant's credibility, where you treat the declarant as witnesses. Hearsay is admitted, opponent can attack or support the declarant's credibility as if the declarant had testified, and you want to keep attacking perception, memory, narrative, capacity, sincerity. There was an example in that famous movie on the fingers, like trying to see the attorney's fingers from afar to negate their perception. But remember, the party cannot use extrinsic evidence to show inconsistent statements on a collateral matter, prove dishonest acts that witness denies, but you can use extrinsic evidence to show impairment of mental faculties. Previous felony conviction, if it satisfies 609, doesn't have to be a crime. Under 609, doesn't have to be a crime of dishonesty. But just think about that 10-year rule of 609. Party against whom the statement was admitted may call the declarant as a witness for cross-examination. So double multiple hearsay is okay as long as every level of statement conforms with the hearsay exception. But remember the Sixth Amendment Confrontation Clause, and Crawford and hearsay. In all criminal prosecutions, accused defendants must enjoy the right to confront the witnesses against the defendants. So this Crawford Confrontation Clause applies to criminal cases. Accused, it protects the accused, so only limits evidence introduced by the prosecutor or from one defendant against another defendant. Confronted, ability to cross-examine the witnesses, people who give testimonial evidence against the defendants. And we look to the 5 principles of the Confrontation Clause. All evidence must satisfy the federal rules of evidence, everything that we've discussed here. It imposes stricter limits. Sometimes the federal rules of evidence don't admit what the what other statutes might allow, or Sixth Amendment applies only to evidence offered against the accused defendant. There is no Sixth Amendment problem if the defendant offers a statement against the prosecutor. If a statement is testimonial, the accused defendant must have a chance to cross-examine the declarant. What is testimonial? The statement that declarant reasonably would expect to use prosecutorially. We look to formality, formal proceedings, solemnity, government involvement, statement made to government, grand jury testimony, and made for purpose of prosecution, to prove fact related to a crime rather than to get help. If a statement is non-testimonial, it's not hearsay. Cross-examination is not required because there's no Sixth Amendment issue. So if the statement occurred before the crime to a private person, no Sixth Amendment issue. So if the accused can't examine at trial, then the prosecutor must establish, which is a difficult standard to meet, declarant's unavailability for trial. Defendant had prior opportunity to cross-examine declarant. Otherwise, a statement will not be allowed into evidence. So look for that within your hearsay rules. On an essay, I just want to talk very briefly about a lot of what we summarized here. Remember to size up the problem, form the essay question, narrative, many pieces of evidence are listed, state all rules, the first time discussed, relevance, hearsay, etc. Issue spot all possible objections or exceptions for each piece of evidence. Look to the transcript, direct cross-examination of a witness. If counsel's question is quoted, objections to form of questions or response. Look to the form of litigation if it's California or federal, civil or criminal, and the sequence of the evidence presented. Read through entire facts and label, plaintiff, prosecution, direct cross rebuttal. General rule is that all evidence is admissible if it is logically relevant and legally relevant. However, two principles limit the admissibility of relevant evidence. First, even relevant evidence may be admissible under specific sections of the California Evidence Code or the federal rules of evidence. And second, all evidence must be properly authenticated to ensure that it is what it purports to be before it can be admitted by the court. So remember, we talked about relevance in our first video. What is the purpose for introducing the evidence? For logical relevance, evidence is logically relevant if it has any tendency to prove or disprove any fact that is of consequence to deciding the case. California is disputed. Generally relevant evidence relates to the time, event, or person involved in the litigation. Special relevancy problems, prior similar occurrences, California Truth and Evidence Amendment, Prop 8. Legal relevance, even if evidence is logically relevant, it can be excluded on other grounds. The court's discretion there, court has broad discretion to exclude relevant evidence if its probative value is substantially outweighed by its prejudicial effect, confusion of the issues, waste of time, undue delay, etc. Or public policy grounds. Character describes a general character trait. In civil cases, character is directly at issue. That might be accepted, like in defamation or other cases. Character is an essential element of plaintiff's claim or defendant's defense. However, in criminal cases, defense can open the door and the prosecution can rebut. How is the evidence being presented? A witness competency, sincerity oath, prior knowledge, present recollection, communication. In California, there's a legal duty to tell truth. Document reliability, the best evidence rule. Opinion testimony, judicial notice, burdens of proof, civil, preponderance of the evidence standard versus criminals beyond a reasonable doubt. Look, in estate and fraud cases, it's clear and convincing evidence. Presumptions. Is the evidence inadmissible hearsay? Remember, hearsay definition is an out-of-court statement offered to prove the truth of the matter asserted. Is the evidence not hearsay because it is not offered for its truth? These are legally operative facts, effect on the listener, circumstantial evidence of declarant's state of mind to show knowledge. Non-human declarations, animal or machine, or a hearsay exception. Can a privilege be invoked? Is there a privileged relationship, like marital, professional? Is there a confidential communication? Who holds a privilege? Was it waived, or an exception? And remember here that for impeachment methods, if we're looking for a conviction of a crime, character impeachment, in an MBE, watch for touchdown facts. Courts do not have discretion to balance for lying crimes. In lying crimes here, lying crimes, perjury, false statement, criminal fraud, embezzlement, false pretense. Witness may be impeached by felonies and misdemeanors, inadmissible if too remote, more than 10 years from the date of release conviction or juvenile conviction. Court has no discretion to exclude the conviction evidence. All other crimes, only felonies, unless too remote or juvenile. So court has discretion to exclude if the witness is the defendant. Prosecution has not met burden of proof showing probative value outweighs its prejudicial effect. If the witness is not the defendant, court determines probative value substantially outweighed by its prejudicial effect. Means of proof are cross-examination there or record of judgment. For the California Evidence Code felonies, all felonies include moral turpitude, are admissible, but court must balance MT for lying, violence, theft, extreme recklessness, sexual conduct, misconduct, not negligent or unintentional acts. Prop 8 doesn't make non-MT felonies admissible because conversation must involve MT to be relevant for impeachment. Misdemeanor under the CEC inadmissible to impeach. Under Prop 8, admissible in criminal cases of MT, moral turpitude, but court must balance. Contradictory facts, for example, is another area for impeachment where we show that the witness mistakes or lie on one point indicates false testimony as to the whole. Admissible under the FRE if the witness's testimony is on a material issue on the case, testimony on a particular fact is significant on the issue of credibility, or witness volunteers testimony about a subject that the other party would be precluded from offering into evidence. Inadmissible to contradict on a collateral matter. Cross extrinsic evidence if not CM there for means of proof. Prior inconsistent statements show that witness has made statements that are inconsistent with her present testimony. You can do this on cross or extrinsic evidence, if not CM. If the FR is met, PIS, prior inconsistent statement, is hearsay, admissible only for impeachment unless made under oath at a trial or deposition or qualifies under a hearsay exception. Then it is admissible to impeach, and a substantive evidence of the fact stated. Foundation requirement: witness has an opportunity to explain, deny the statement. Adverse party is given an opportunity to examine the witness regarding the statement. No foundational requirement for opposing party admission or by H declarant. Justice requires. For the CEC, prior inconsistent statement offered to prove the fact asserted is hearsay, admissible to impeach. Broad California hearsay exception allows all of witnesses' inconsistent statements to be admissible. Bias or interest is another area of impeachment to show a witness's motive to lie under the FRE. If FR is met, then always admissible for impeachment. FR asks about the facts showing bias on cross, so a witness can explain or deny. Note: other party may not subsequently show that the witness bias is justified. Means of proof for cross and extrinsic evidence. Specific instances of misconduct, bad acts, subject to court's discretion. Cross-examiner can inquire in good faith regarding specific acts of misconduct bearing on honesty or truthfulness. No FE allowed if witness denies the specific acts. Note: arrest is not a bad act, specific act. Means of proof for federal or cross, for California cross and extrinsic evidence, subject to CEC 352. Admissible though, inadmissible on the CEC, but under Prop 8, admissible in crime cases if relevant because the crime was of moral turpitude. So opinion, reputation for truthfulness, show witness is a liar, can use reputation, opinion, evidence of witness's bad reputation for untruthfulness in business circles or community, other witnesses' testimony. And lastly, sensory deficiencies to cast doubt. You can show that witnesses' faculties of perception and recall were so impaired or that she had no knowledge of facts. You can do that on cross or extrinsic evidence. Remember, COPT is bad reps, where we say MBE, PIS / contradictory facts. For extrinsic evidence on a CM, correct answer will often say unfairly prejudicial for waste of time or confusion. Okay, almost done there. We're just gonna do a quick review of all of this. So remember relevance. Irrelevant evidence is inadmissible. Relevant evidence might be admissible. Evidence is logically irrelevant if it has any tendency to make the evidence the existence of any fact that is of consequence to deciding the case. California and in dispute, material, more or less probable than it would be without the evidence probative. Generally, relevant evidence relates to the time, event, or person involved in the present litigation. Prior similar occurrences, evidence is not admissible to show that the person probably acted the same way again. Exception: such evidence may be logically relevant if there are similarities between the evidence and the people or events at issue. Remember this as chirpy, as causation, habit, intent, or remember this as causation, habit, intent, industrial custom, routine business practice, rebut of a defensive possibility, pre-existing condition, pattern, fraudulent claims, established value. So in California, truth and evidence, Prop 8 makes all relevant evidence admissible in criminal cases, even if objectionable under the CEC. For PHSCC, exceptions are privilege, hearsay, secondary evidence rule, USC exclusion rules for confrontation clause, limits on character evidence to prove defendant or victim's conduct. CEC 352, court's power to exclude if unfair prejudice substantially outweighs probative value. So even if evidence is logically relevant, it may be excluded on other grounds. Judicial discretion: court has broad discretion to exclude logically relevant evidence if empty cup, misleading the jury, waste of time, cumulative, confusion of issues, undue delay, probative value substantially outweighed by unfair prejudice, emotionally disturbing, could be used for an inadmissible purpose. MBE: unfair surprise is not valid. Public policy reasons: MBE, if admissible is correct, look for answers that say inadmissible for reasons of public policy. Evidence: for Mrs. Lee, payment or offers to pay medical expenses, humanitarian gestures under the FRE, and admissible to prove liability from the injuries in question. Related statements inadmissible unless part of settlement offer. Related statements are inadmissible under the CEC. Under the FRE, safety measures or repairs after accident, encourage repairs, inadmissible prove culpable conduct or negligence, product liability, inadmissible prove defect or product design, and B, admissible to prove ownership or control over the condition that caused damages if this is at issue, was possible to have a safer condition if this is a defense, not available under product liability for the CEC. Settlements, we want to encourage settlements. For civil, settlements offered to settle related statements are inadmissible to prove liability or fault, as we discussed. For criminal, pleas later withdrawn, offers to plea related statements inadmissible to prove guilt, including guilty nolo pleas. Exceptions, no claim filed or threatened, no dispute regarding liability of damages. Under the CEC, civil discussions during mediation proceedings are also inadmissible. Under criminal, it's unclear if P8 applies to make it admissible. Even if Prop 8 applies, court may still exclude the evidence for unfair prejudice under CEC 352. For liability insurance, we want to encourage people to maintain insurance. It's inadmissible to prove culpable conduct like negligence or defendant's ability to pay a judgment. Expressions of sympathy there. No such rule, but however, in California, inadmissible if relating to suffering or death of an accident victim. Statements of fault are admissible. So character evidence. What is the purpose for which character evidence is offered? Character evidence describes a general character trait and may be offered as substantive evidence to prove character when it is the ultimate issue in the case, as circumstantial evidence of how a person acted on the occasion in question, conduct, or to impeach or support the credibility of a witness. And so we ask what method of technique is used to prove character, specific acts or conduct, opinion, or reputation. And then we talk about here that we ask, is it a civil or a criminal case? If it's a civil case, if a litigant has a purpose other than to show propensity and the evidence is relevant, then it is admissible. Character evidence is generally admissible if character is directly at issue, like claims of defamation, negligent entrustment, child custody, loss of consortium, fraud, self-defense. You can use reputation or opinion or specific acts. Character is an essential element of plaintiff's claim or defendant's defense. Sexual assault, child molestation cases, and in the federal rules, specific acts you can use. They're admissible, but in California, specific acts are inadmissible. If a party testifies that she automatically places her credibility for truthfulness in issue, other party can impeach but can't offer substantive character evidence. Criminal admissibility of evidence of defendant's character to prove conduct. Prosecution cannot be the first to offer such evidence, as we discussed, or is closed at the start of trial. Not available under P8 for California. Exceptions, special cases, specific acts are admitted. There, federal and California sexual assault, child molestation, California domestic violence or elder abuse, where there's an exception there. So look for sexual assault, child molestation, or domestic violence, elder abuse in California. But also in California, sexual assault and child molestation. It's just that in the federal rules, they don't allow the exception to apply where the prosecution can first put in specific acts for domestic violence or elder abuse. Court-admitted evidence of victim's character. Prosecution may offer evidence that defendant has same character trait. In California, violent character trait only where this applies. Defense can open the door by presenting relevant reputation, opinion, evidence of defendant's good character to show that defendant acting in conformity with his good character trait and did not commit the crime charge. Caution, if defendant's crime is violence, peacefulness is relevant and honesty is never relevant, only in forgery or perjury. If defendant testifies, he automatically places credibility in issue. Prosecution can impeach, but can't offer substantive character evidence. Prosecution can rebut with reputation or opinion evidence concerning a pertinent character trait relevant to substantive claim, but no propensity evidence. Prosecution can never introduce evidence of defendant's bad character if the purpose is to show that defendant probably acted in the same way and committed the crime charged. So exception for specific bad acts. Specific acts subject to court's balancing. If there's sufficient evidence to support jury finding that defendant committed the act, then relevant specific acts of misconduct can be used to prove motive, intent, mistake, identity of defendant, or common plan or scheme. Mimic, or you can remember this as, we called it kipomia, but mimic is another way you can remember. Where on direct or rebuttal, you're allowed to use reputation, opinion, or specific acts for mimic. For cross, you're allowed to use reputation, opinion, specific acts, but the prosecution is limited to inquiry of witness or even regarding defendant's arrest, but can introduce extrinsic evidence. In California, you can use reputation and opinion, but no specific acts unless you're in that exception for elder abuse, domestic violence, or some sort of sexual crimes case. So admissibility of evidence of victim's character to prove conduct. Prosecution, again, cannot be first to offer such evidence. Doors close at the start of trial. In California, PA is not available. Defendants can open the door by presenting relevant reputation, opinion, evidence of victim's bad trait to show defendant's innocence. By pleading self-defense in a homicide case, prosecution can then rebut with character evidence concerning a pertinent character trait relevant to the substantive claim. Federal and California prosecution may rebut with character evidence for the same trait of victim's good character or defendant's bad character. Federal homicide, if defendant pleads self-defense and offers evidence that victim attacked first, prosecution may offer evidence of victim's peaceful character. So reputation opinion is available on direct there. But in regards to the admissibility of victim's character to prove conduct, in California you're allowed to use reputation opinion in specific acts there for the victim. In the federal rules, only on cross can you use the specific acts. Rape shield in rape, sexual assault cases, evidence of alleged victim's sexual behavior, disposition is inadmissible. Exception is criminal. Specific instances of victim's sexual behavior is admissible to prove third-party source of the physical evidence or injury. Prior acts of consensual intercourse between defendant and victim. Exception, civil, reputation, opinion, specific instances, evidence is admissible. Probative value substantially outweighs the danger of harm to victim and of unfair prejudice to any party. For reputation evidence, victim must have put her reputation in issue. So hearsay, not available in California for the Prop 8. Definition, person's out-of-court statement offered to prove the truth of the matter asserted in the statement, admissible upon appropriate objection because the adverse party was denied the opportunity to cross-examine a declarant when the statement was made. MBE, testifying witness's own out-of-court statement is hearsay. Examples, I told the police I saw, don't pick answer. Not hearsay because it is not, it is witness's own statement. Fairness, when you introduce part of a statement, adverse party may introduce any other part, which in fairness should be considered. Following approach, identify the statement, verbal, written expression, or conduct intended to communicate, determined by circumstances. Identify the declarant. If declarant is a party, statement is in admission. So admitted, if non-party, continue on with your analysis. Is a statement out of court? Any statement is not made in the current proceeding is out of court, even if from first trial. Is it offered to prove the truth of the matter asserted? If question doesn't say, ask what is relevant to prove in the party's case. Will the jury be misled if the out-of-court statement was speaker was lying or mistaken? If yes, statement is hearsay. Check for exceptions. Not hearsay. DIE is the acronym. Statements with an independent legal significance, verbal acts, legally operative facts, words of a contract, defamatory words. Statements offered to show their effect on the listener, reader. Exception to prove notice or knowledge of a fact. Statements offered as circumstantial evidence of a declarant's state of mind, evidence of insanity or knowledge. Caution, don't confuse with statements directly reflecting declarant's state of mind, which is a hearsay subject to an exception. Prior inconsistent statement is not hearsay if just offered just to impeach. Exemptions. So admissible for substantive truth if declarant testifies and is subject to cross-examination, but there are no exemptions in California. Opposing party statement, relevant statement by a party or attributed to a party made at any time that is offered by a party opponent. California party opponent admissions, hearsay but admissible under California exception. Statement need not be against declarant's interest when made, can be opinion. Prior knowledge not required, can be predicated on hearsay. Formal judicial admissions and pleading stipulations, adoptive admission, reasonable person would have protested but party remained silent, accusation silence are admissible. Vicarious admissions, agent rematters within scope of his agency, prior statement, co-conspiratorial statement, extrinsic evidence regarding matter within scope of EMP during EMP relash, only if EE's negligence made ER liable under respondent superior, not joint tenants, co-parties, spouses. Other examples, I'm just rushing through a lot of this, so you can skip this part. I'm just gonna reread a lot of what we talked about, or you can play this slowly on YouTube, since there's a lot to cover here and we have to really move on to the next subject. So remember here that okay, prior statements by a witness in the current case. Prior consistent statement given under oath at trial, deposition is exempt even if offered to prove facts asserted, can be substantial evidence and to impeach. California prior consistent statement is hearsay if offered to prove truth of facts asserted, but all prior consistent statements, whether or not they're under oath, are admissible under exception. Prior consistent statements that are offered to rebut charge that the witness is lying or exaggerating, of some proper influence or motive, admissible if made before the bribe, rehabilitated witness whose credibility has been impeached on a ground other than truthfulness. Note that prior consistent statement is not admissible if the witness was impeached by prior conviction or bad act. California, prior consistent statement is hearsay but admissible under the California exception. Identification of the statement of identification made under witness to perceive the person can be a sketch the witness made with a police artist. Exceptions, hearsay, but these are hearsay but still admissible under an exception. Prior and consistent statement admissible under exception can be substantive evidence and to impeach. Declarant unavailable, diff, D-I-F-F. And so we like to remember these as declaring declaration, interest, family, history, former testimony, forfeiture. And so unavailable if prima, privilege, refuses, in a federal despite court order, California out of fear, physical or mental illness, dead, memory, federal, doesn't remember, California total memory loss, absent, memory beyond reach of court subpoena, and proponent is unable to procure attendance by reasonable means. Unavailable, hearsay declarant be impeached by evidence that would be admissible if declarant testified as a witness. Dying declaration, admissible in civil or homicide. Declarant believed his death was imminent and the statement concerned the cause or circumstances of what he believed to be impending death. Declarant does not need to die. California exception applies in all civil and criminal cases. And declarant need not be dead. Or declarant must be dead. Their statements must be based on declarant's actual knowledge. Cannot be a statement of a mere suspicion. Statement against interest, admissible if at the time when it was made it was against the declarant's financial interests or would have subject her to criminal liability. And a reasonable person in the declarant's position would have made the statement only if she believed it to be true. Declarant must have prior knowledge of the facts and know it against her interests to make the statement. If statement is offered to exculpate an accused, there must be corroborating evidence to admit the statement, such as a confession. California also within the exception is a statement against social interest because it makes making the declarant an object to hatred, ridicule, or social disgrace in the community. Statements of personal family interest admissible to prove declarant as a member of family based on declarant's prior knowledge. Former testimony of a now unavailable witness given at trial, hearing, deposition is admissible if party against whom the testimony is offered was a party in the former action. Federal civil case predecessor in interest was a party in former action, privity type relationship, grantor, extrinsic evidence, joint tenants, testator, executor. Former action involved the same subject matter, so party had the same motive to examine as she does now. Testimony was given under oath, hearing, trial, deposition. Party against whom testimony is offered had an opportunity to develop the witness's testimony at the prior proceeding. California civil case similar interest standard, a party in the earlier proceeding had an opportunity to examine witness and interest to conduct that exam similar to the interest of the party against whom testimony is now offered, or prior or former testimony is now offered against a person who offered an evidence, her own belief, or in the early proceeding against a successor. In interest of such person, related California law, depot testimony from the same action offered at trial. For all purposes, if the opponent is unavailable or at trial or lives more than 150 miles from the courthouse. Forfeiture, statements offered against a party are admissible when offered against a party who has engaged, acquiesced in wrongdoing that intentionally procured the declarant's unavailability. Declarant's availability immaterial in present state of mind, physical condition, circumstantial evidence offered to show a defendant that existing state of mind, emotion, sensation, or physical condition is admissible, not memory, belief, usually to help establish intent that intent was carried out. Cited utterance, statement relating to a startling event made while declarant was still under the stress of the excitement. Present sense impression, statement explaining an event made while declarant was perceiving the event or immediately thereafter, must be contemporaneous, such as being on the phone, not recounting an event a short while term. Later, California only statements explaining declarant's conduct made while she was engaged in the conduct are admissible. Related California exception, statement made at or near time of injury describing infliction or threat of physical abuse in writing or recorded or made to police or medical professional under trustworthy circumstances. Caution, testimonial evidence that police could violate confrontation clause if police are gathering hearsay to rebuild the case against defendant, but not if there is an ongoing emergency when declarant speaks to the police. Statements for medical diagnosis or treatment. Statement about the nature of an injury, a medical condition, or its cause is admissible if it is made for and is pertinent to medical diagnosis or treatment. Statements of past or present mental or physical condition are admissible if made for medical diagnosis or treatment only if declaring as a minor describing the act of child abuse or neglect. Related California exception, statement declarant's past physical mental condition, including statement of intention, is admissible to prove that condition is if it is an issue in the case, no requirement that statement may be made for medical purposes. Declarant must be unavailable. Business records, records of events, conditions, opinions, diagnoses, kept in the regular course of business, made at or near time of matters described by a person with prior knowledge of the facts or who recommended the info from person with prior knowledge of the facts who transmit in the ordinary course of her business, and its authenticity can be established, admitted to prove what is and is not in the record. Court can exclude if opponent makes showing that circumstances of the writing indicate lack of trustworthiness. California rule does not refer to opinions or diagnoses, but courts will admit simple opinions and diagnoses. Public records, any of the following are admissible, describes activities and policies of the office, describes matters observed pursuant to duty imposed by law, not police reports in criminal cases. California record made by public extrinsic evidence is admissible if making record was in scope of duties. It was made at or near time of the matters described, and circumstances indicate trustworthiness if gathered by police. Possible CC violation contains factual findings from investigation made pursuant to authority granted by law, civil and criminal, against government only. Prior criminal convictions, defendant's felony conviction is admissible to prove any fact essential to judgment. Non-defendant can only use to impeach. This exemption only applies in civil cases. P8 not available, but a certified copy of a judgment of conviction is admissible under the California Public Records exception in both civil and criminal cases. Market reports and other published compilations are admissible if generally used and relied upon by public or people in an industry. And remember the confrontation clause, where an out-of-court statement, and remember this part, an out-of-court statement is they're inadmissible if the declarant does not testify at trial and is now unavailable. The statement is testimonial, and defendant has not had a chance to cross-examine declarant when the statement was made. Testimonial statements made in court, statements made to further police investigation that are aimed at producing prosecutorial evidence. So remember, testimonial evidence, competency, only a competent witness can testify. Jurors and judge incompetence in this proceedings, for example. Requirements are special, sincerity, witness must take oath or make affirmation to tell truth, personal knowledge, fact testified to is a fact perceived within one's own witness's senses, but don't need perfect perception. It can be in the dark. Present recollection, witness must testify from present recollection, not something witness once known but has forgotten. Communication, witness must be able to relate perception either directly or through interpreter. California only, witness must understand the legal duty to tell the truth. Other grounds for DQ disqualification are abolished, such as age, atheist, psychiatrist is liar, incompetent, hypnotized to refresh recollection. California disqualifies witnesses who are hypnotized except in criminal case if police use procedures that protect against suggestion. Dead man statute, civil suit against an estate. Interested parties incompetent to testify to transaction communication with decedent. Objections to form of testimony and questions. Objections must be timely after question, before answer, and specific, otherwise waived. CalNew compound assumes facts not in evidence, argumentative, leading, cross, okay if within scope of direct. Direct not okay to have these leading questions unless the witness is adverse, hostile, needing help, age, mentally incompetent, calls for narrative, unresponsive. Witness use of documents during testimony, watch for hearsay issues, refreshing recollection. Anything can be used. Opponent may inspect and offer into evidence. Witness can't read from it into answer. For hearsay, recollection, record recollection exception to hearsay. Witness reads document but still can't remember plaintiff's case because the document is now the only source of evidence. Plaintiff's counsel must offer it into evidence. Requirements, Puma Rihanna. Witness once had prior knowledge of the facts. Document was made by witness under witness's direction, was adopted by witness. At a time when facts were fresh in witness's memory. Doc was inaccurate, was accurate when made. Witness now has insufficient recollection to testify as to matters contained in the document. Opinion testimony, lay opinion admitted if rationally based on witness's perceptions and helpful to the trier of fact. Rationally based, logical connection between perception and opinion, sufficient perception, got a good look. Helpful, lay opinion gives the jury more info than if witness's testimony was limited to describing just their perceptions, cannot be based on scientific, other specialized knowledge, legal conclusions, permitted to assist speed of auto, sanity, intoxication, emotions, value of witness's property. Expert opinion, Expert witness believes an opinion to reasonable degree of certainty. Some doubts are okay, helpful to jury. Expert witness uses specialized knowledge to reach conclusions the average juror could not figure out herself. Expert witness is qualified based on education or experience. Testimony must be an area of expertise. Opinion is supported by proper factual basis based on admitted evidence, prior knowledge, inadmissible evidence reasonably relied upon. MBE, hypothetical question is okay. Check the facts that the admissible evidence given to witness are a correct statement of admissible evidence. Opinion is based on reliable principles that were reliably applied. Scientific opinions, Dalbert, PETA, peer-reviewed, published, low error rate. Results are tested and there is ability to retest. Reasonable level of acceptance. California, Kelly, and Fry opinion must be based on principles generally accepted by experts in the field, not available to non-scientific operations and medical operations, reliability of which is based on facts and circumstances of the case. Non-scientific evidence, Kumho, reliability is determined by looking at the facts and circumstances of the case. Learned treatises, hearsay exception. Learned treatises, it is admissible to prove anything stated therein if it is an accepted authority in the field. Learned treatises is only admissible to show matters of general notoriety or interest. Narrow, rarely applicable. Evidence of witnesses' credibility, caution, hidden hearsay issue. If witnesses' prior statement is offered to attack, support credibility, inadmissible unless credibility is attacked first because you can't bolster your witnesses' credibility. If witnesses impeached for bad reputation, prior convictions, prior bad acts, can rehabilitate with opinion, reputation, evidence for witnesses' good reputation for truthfulness. If impeached on other grounds, the law is unclear. Impeachment, think about Carr, casting an adverse reflection on the veracity of the witness. Attacking witnesses' credibility for truthfulness. Step 1 is a source of impeachment, extrinsic evidence, or the witness's own testimony at the proceeding. Extrinsic evidence, any evidence other than testimony given at the proceeding by the witness being impeached. Examination, witness is usually impeached on cross, but can impeach your own witness. If extrinsic, is it admissible given impeachment technique? And also look for any foundation requirements. Almost done. So sorry for going fast. There's lots to cover here. You can always play it slow. A lot of this we talked about already. I just want to cite it, I guess, for my own benefit too, and for yours also. You can always slow down the video and hear everything that I'm saying. A lot of it is what we covered before. So writings and other physical evidence. Authenticity is the first aspect of relevancy. Authentication, every item of non-testimonial evidence, writings or photos, must be authenticated by proof showing it is what the proponent claims it to be. Proof must be sufficient to support a jury finding of genuineness. It's a very low threshold. It can be testimony. Methods of authentication, chain of custody, required for non-unique items to demonstrate if the specific item proponent claims it to be non-unique. Anything factually indistinguishable from other like terms or like items. Bag of white powder, generic gun. Pleadings of stipulation, genuineness of a document may be admitted by the pleadings or by the stipulation of the parties. Evidence of authenticity, admissions, party against whom the evidence is offered has either admitted its authenticity or acted upon it as authentic. Eyewitness testimony, eyewitness sees it executed or hears it acknowledged. Handwriting verification by expert witness, non-expert witness with prior knowledge of writer's handwriting, can't become familiar just to testify. Trier of fact with sample comparisons. Voice verification, anyone who had heard the voice at any time prior to the call. Expert witness, trier of fact, reply letter, doctrine, authentication by evidence that was written in response to communication sent to claimed. Author, ancient documents at least 20 years old. California, it's 30. Condition free from suspicion, found in likely place to be kept. Photographs, identification by witness as portrayal of facts relevant to the issue and verified as correct representation of the facts. Witness familiar with the scene is sufficient, don't need to call photographer to authenticate. Unintended camera, show properly operating as relevant time. Photo developed from film obtained from that camera. X-ray, electrocardiograms, etc. can't be authenticated by witness's testimony. Must show process is accurate. Machine was in working order. Operator was qualified to operate. Custodial chain must be established. Authorized, not required. Federal and California, PANO. Certified copies of public records, acknowledged docs, newspapers, official government publications, federal only. Certified biz records, trade inscriptions, and these are tags or labels that purport to have been attached in the course of business and indicates ownership or control or origin. Applies if writing is a legally operative or dispositive instrument. Witness's knowledge is from having read the document. If the facts can be proven without the writing, this is not an issue. MBE, rarely the correct answer. Writing, documents, videos, photos, x-rays, audio recordings, computer disks, any tangible collection of data. Original, writing itself for copy intended by the person executing it to have the same effect. Exact copy, duplicate. California admits duplicates and other written evidence of contents of the original, including handwritten notes. Voluminous documents exception documents can be summarized if originals are available for inspection. Privileges. FRE grants the court power to establish privileges. In diversity cases, state privileges apply in federal court. Privilege is personal to the holder. Sometimes they may be asserted on the holder's behalf. Requirement: if to be privileged, a communication must be shown or presumed to have been made in confidence. Eavesdropper's privilege is not abrogated because of eavesdropping unless holder was negligent. Waiver: failure to claim privilege. Voluntary disclosure by holder. Contract provision: waiving the privilege in advance. MBE: privilege is not waived when someone wrongfully discloses info without privilege holder's consent. Waiver by one joint holder does not affect the right of the other holder to assert the privilege. Neither counsel for the parties nor the judge may comment on a claim of privilege. Privileges recognized by federal courts. Attorney-client: protects confidential communications between attorney and prospective client or their representatives made during any professional consultation. Privileges survives indefinitely. Even if client dies, client fires attorney doesn't take the case. California privilege ends once estate of dead client is distributed and executor of the state is discharged. Corporations privilege applies to communications from EE agents if authorized by the corporation to speak with lawyer on corp's behalf. Privilege applies if extrinsic evidence agent is a natural person to speak to the lawyer on behalf of the corporation in the matter, or extrinsic evidence agent did something for which the corporation may be held liable, and corporations instructed her to tell a lawyer what happened. No privilege for a mere witness who happens to be an extrinsic evidence. So exceptions: no privilege if services ought to further what client knew or should have known to be a crime or fraud. Communication relates to an alleged breach of duty. Attorney represents all parties to a dispute. Additional California exception: lawyer reasonably believes disclosure is necessary to prevent a crime likely to result in death or substantial bodily injury. Marital privileges not available in civil cases between spouses or criminal cases if one is charged with crime against other kids. Spousal testimonial privilege: criminal cases only. A spouse can never be forced to testify against her spouse, and if spouse is the defendant, she can invoke the privilege to not even be called as a prosecution witness. Held by witness spouse only, so she can volunteer to testify and spouse can't stop her. Privilege only lasts during marriage. Applies in civil and criminal cases. Privilege for confidential marital communications: protect confidential spousal communications during marriage, held by both spouses, so either can prevent the other from disclosing. Divorce does not terminate the privilege, but communications after privilege are not privileged. After divorce are not privileged. Psychotherapist, patient, social worker, client, made to facilitate rendition of professional services, operates like attorney-client. Exceptions: patient puts physical mental condition in issue. Services sought to aid in crime, fraud, or escape. Alleged breach of duty, malpractice action. Patient agreed to waive by contract, insurance policy. Additional California exceptions: psychotherapist has reasonable cause to believe the patient is a danger to himself or others, and disclosure necessary to end the danger. Clergy privilege exists for statements made to a member of the clergy, operates like attorney-client. Government official information not otherwise open to the public. Performance: California, if no statute. Judge has discretion. Privilege not recognized by federal courts but recognized by most states, including California. Doctor-patient info conveyed for purposes of obtaining diagnosis or treatment, and info was pertinent to diagnosis or treatment. Exceptions: patient puts physical condition at issue, personal injury, suit, services sought to aid in criminal, fraud, escape, alleged breach of duty, malpractice action, patient agreed to waive by contract, insurance policy, federal case. Additional California exception: privilege not available in criminal cases or info. Doctor is required to report to public office. GSWs. California only privileges: counselor, sexual assault, domestic violence, professional journalists. Judicial notice: process of establishing facts without presenting evidence. Facts appropriate for judicial notice: courts can take judicial notice of facts not subject to reasonable dispute because they are either indisputable, facts are generally known within the jurisdiction, or in California, whether requested or not, court must take jurisdiction. Court records: verifiable facts established by sources of unquestionable accuracy. Calendar: procedure for taking judicial notice: party must request judicial notice, otherwise court has discretion to take judicial notice, can occur at any time, even appeal. Civil: court instructs jury it must accept a notice fact as conclusive. Criminal: court instructs jury it may, but is not required to accept judicial notice fact. California jury must accept. Effect: party prosecutor's burden of producing evidence on the matter is satisfied. Test notes: MBE, clearly wrong answers. Inadmissible because it is not the best, because of the dead man statute, because evidence is self-serving and prejudicial. The statement is part of the res gestae. All Latin is wrong on evidence questions. Dramatic TV objections: California distinction: always apply FRE on MBE and essay unless essay question says to apply CEC. Assume CEC and FRE are the same unless California outline specifies a difference. Criminal case essay: mention truth and evidence amendment to California Constitution, Prop 8. Essay approach: raise all objections under the CEC. And for each objection mentioned, if Prop 8 overrules objection, is the evident relevant? Does a Prop 8 exception apply if evidence seems admissible under Prop 8 balance under CEC 352? So sorry I was going really fast. I just want to repeat that for the record. Thank you so much for listening, for all my friends that provided insight for me to use. Thank you so much. Best of luck on evidence. We'll try to do criminal law next. Keep doing practice questions and rewind to any of the topics we discovered. I tried my best to cover as many topics as would be tested on the bar. So best of luck.